We're going to talk about something that really is and should be at the forefront of any case that we're handling as a plaintiff attorney and as a defense attorney. So what is that?
Today, we're going to be talking about civility in the legal profession. And we think this is a really important issue to discuss because we are on opposite sides of the aisle. I'm a defense attorney. I represent corporations, and Alexis represents plaintiffs. But typically in the law, nothing is black and white. And so we can always agree on something.
With respect to employment cases, let's talk about that, because these cases are unique in that you're not talking about two strangers who collide on the road where they don't know each other before the incident occurs. Employment cases, as you know, Gabrielle, can be extremely contentious given the long-standing relationships that are oftentimes involved, right?
Right. What makes these employment law cases so contentious is that it's an employee for a company and they often know the person very well who may have wronged them. You know, it's our job, both of us, me as a defense attorney and you as a plaintiff's lawyer, to really advocate for our clients and to really understand their positions and maybe the weaknesses in our case. But I think what's most important is for us to understand that to be strong advocates for our clients doesn't mean that we have to be contentious amongst ourselves and with our, opposing counsel.
What does civility mean to you, Gabrielle?
Civility to me means acting in a professional way, in a respectful way. I think that the most important thing really is that the public has trust in us as attorneys and in the legal system in general. And so I think that when we behave in a civil manner, we're doing the right thing by our profession, and the public is able to trust us as attorneys and the standard that we're held to.
Yeah, I think the public oftentimes has a misconception about attorneys as being in love with the fight. And there's nothing wrong with that, but it doesn't need to be about ad hominem attacks. And something that I do in my practice is I try to start the relationship off with defense counsel in my cases as cordial and as professional, while still representing my client as zealously as I can. And how do I do that? So oftentimes the first communication that I have with an opposing counsel, such as yourself, and to clarify, we've never had a case against each other. We don't currently have one.
Not yet.
Each other.
I imagine there's going to be a day when a demand letter from you comes across my desk. And I know, because we have had a civil relationship and we're, friends outside of being attorneys, I know that we can both advocate for our clients and do them justice, and respect each other. And that's what ultimately gets the best results for our clients and for the case, whether it's, fighting it out and litigating in court or whether it's going to an early mediation and resolving it. I think what both of us need to focus on is doing what's best for our clients.
Yeah, absolutely. The idea is that we work together to advance the case. That's the goal for you and for me as a defense lawyer and as a plaintiff's lawyer, to move the ball forward.
Absolutely. Generally, I try to take, when I start out and I meet a new opposing counsel for the first time, I take a respectful tone and I'm friendly and quite frankly on myself. And I don't get aggressive unless that person is aggressive with me first. But I think that it's important to stand your ground and advocate for your client. And you can do that being respectful and kind. I think the best way and how I approach dealing with plaintiff's counsel is probably speak softly and carry a big stick, although I probably don't really speak softly. I'm pretty loud. The question for you, what do you do when, I know you like me, what do you do when there's opposing counsel on the other side that you just don't like, you don't get along with, that person has rubbed you the wrong way? How do you handle that to best advocate for your client?
So the short and sweet answer is I just put blinders on. And I focus on the facts of my case. I focus on the case itself. And I don't let that outside noise interfere with what my end goal is, which is justice for the client. On the plaintiff side, we love to say justice delayed is justice denied. So I don't want unnecessary extensions going forward. But also, I'm a human being. I understand that things come up from time to time, and I want to be courteous and I want to be civil, but that cannot be abused.
Absolutely. I think it's important to recognize that someone is being kind by granting you an extension and not abusing that process. I think also, though, it's important to understand, in certain cases, in employment law cases in particular, oftentimes there's an insurance carrier at play. There's other factors at play. And so the other side is not jerking you around for no reason. Perhaps, the person in HR that you need to speak with is on vacation. So there's, a lot of reasons why you might not be getting a response or answers from the other side. And it's not to delay justice. I mean, the clients that I represent want to do the right thing.
I am generally a very warm person, but my tone definitely does change based on the type of case that I'm handling. I think that my tone changes based on the severity of the allegations at issue. I can tell you that when I'm handling some serious sexual harassment cases, there is a very different side of me that comes out in litigation or in my emails. Your body language, everything changes when you really deeply believe in your case. And certain cases are more egregious than others, so there is a spectrum about the mood and the tone that each case takes on. It has a life of its own.
Absolutely. But I think you need to understand that it's not the lawyer on the other side who, committed or may have not committed the acts that your client is alleging. And so you can take a strong stance and represent your client without, making it personal against the attorney. Not that I believe you do that, but I hear you. Sometimes the facts are difficult. It's not always easy when you see cases like that. But I think that what's important is when you have a good relationship with the other side, that's when I'm able to see a fact pattern. I see a demand letter and I know, okay, maybe there is some liability here for my client. Or, maybe the other side is completely lying and none of this is true. And I think when you have a good relationship with the other side and you really trust each other because it's a small world and we're going to see each other, you're going to see the same lawyers again and again on multiple cases. And I think when there's trust, you're actually able to properly value the case and what liability might be and what's actually worth. Do you have any experience with that?
Yeah, I think that having an open line of communication from the beginning is very helpful. For example, I really appreciate when a defense attorney, after receiving a letter of representation from my office, picks up the phone or emails me to schedule a call. Instead of slinging letters back and forth, that can be pretty contentious from the beginning, but when you pick up the phone and you start having the small talk, which actually holds a lot more meaning than people realize, it advances your case in a way that otherwise would not happen.
I absolutely agree with that. I think also when there's communication and really we just pick up the phone, which is a lost art, honestly, with so much back and forth email. One, I think you see that the tone of people is different on the phone. Some of the insults I've seen in emails would never have flown if someone said that to my face or over the phone. That just wouldn't have happened. But I think also when you have those conversations, the case remains top of mind.
And I view every communication as a touch point on the case. I sometimes will strategically plan out my outreach to defense counsel across several days on different issues, discrete issues, so that my case, like you said, always stays top of mind. And that's what I owe to my clients, is for their matter to be at the forefront and to keep that case moving forward, because there are enough delays that are intrinsic to the justice system, which I combat in my practice and I work on through various channels. But I think that we have to do what's in our power to either reach resolution or to move that case towards trial, because it cannot be an indefinite process that's hanging over the heads of both sides, because that does not help either side move forward and move on. And for me, when I'm representing individuals, it's so important emotionally and in their professions to be able to take those steps forward.
Absolutely. And I think that the corporations that I represent also want to resolve these issues. I mean, no one wants a pending lawsuit or a lawsuit just looming over their heads forever. And I think that since COVID, the court system is really backed up and, these cases don't go to trial for many years. I mean, sometimes I have a case right now that's more than 7 years that it's been pending, and it's, an employment law case, which is unusual, but that's kind of the reality of the situation now. And so I think when these cases last so long, you really have the opportunity to get to know the other side really well. And I think advocate for your client, and moving the case forward.
Yeah, moving forward is the goal, right? Like, progress is the goal. The counterpoint that I will say is that I do think that the pacing of cases and their ability to move through the system faster is improving. And as a plaintiff's lawyer and as someone who's actively involved in these communities where we're trying to push legislation to make the process move smoother and move faster, then, my perspective is that it's improving, and I will do everything in my power to keep each case moving forward as expeditiously as possible, because I think that both sides owe it to their clients to do that.
I think that sometimes the defense side gets this reputation of delaying and slowing down.
How do you feel about that? Like, how do you feel about that being the reputation? I mean, it's not true for every attorney or every defendant, right?
Well, here's the thing. I think that it's my responsibility to represent my client and do what's in my client's best interest.
I'm really curious, from the perspective of a plaintiff's attorney, what are some things that your opponents, your plaintiff's attorneys on opposite sides of the cases that you handle, tell me about a few things that they have done that have really caught your attention in a positive way that you think those plaintiff's lawyers who are listening to this could benefit from.
So what I think that plaintiff's lawyers have done really well is when they're able to really communicate to their client what is going on in the case, and so that their client has a fair expectation of the value of the case. When an attorney really communicates to the plaintiff and explains liability and what they can really recover, I think that that's something that I really appreciate, because then that matter can actually get resolved. How about you? Yeah. What have you seen defense attorneys do that you appreciate, that you would want to see more of?
Yeah, I've gone up against a very wide range of defense attorneys. I mean, like I said, I have my own firm. I've had my own firm for a number of years. I've gone up against other solo defense attorneys, but most of the time I go up against national, if not global, law firms. And so I've seen it all. And what I see as far as defense attorneys who are effective and courteous, but at the same time being strong advocates for their client, some of the high points that I could reference would be, like I said, picking up the phone, having that initial conversation, meeting, live in a way that paperwork doesn't accomplish. That's one thing. The second thing I would say is asking me, for certain things that they need to get whatever authority that they need on their side to help the case resolve, if that's the mission on the case. Now, I, as the plaintiff's attorney, I have to not only be an advisor and a counselor, but I also have to be a great listener and understand what my client's objectives are.
I call you a therapist, something I could not do, which, I'm not a plaintiff's lawyer, so I don't have to play the role of therapist and counselor, just counselor over here.
Yeah, disclaimer, I'm not a medical professional or anything like that, but
we joke.
Yeah, we joke. But truly, I do have to listen and understand my client's objectives so that I can plan a case accordingly. And so when I get a defense lawyer and that person is asking me, hey, I need X, Y, and Z, for example, I need to know, is your client employed? Have they obtained comparable employment?
Emotional distress damages. Those are questions I always ask. And if you hide the ball on that, the matter's not going to resolve, because we ultimately, to potentially get the authority before going into a mediation, I really need to know what are the actual damages. And when a lawyer hides the ball, I can't get authority, and that's potentially not in anyone's best interest if we can't resolve the case.
Yeah, so we have to work together to support the flow of information between the two sides. I think if we had to end on something that we can stipulate on here, I would probably say that civility means, in part, having an open line of communication with the other side. What do you think?
I absolutely agree with that. And to that, I say, so stipulated. All podcast episodes provide general information and do not constitute legal advice to any person with respect to any circumstance. This podcast does not create an attorney-client relationship with any person. All opinions reflected are our own. Submit your questions to the podcast to sostipulated1@gmail.com and follow this podcast on Instagram @sostipulated. Personal contact for me, Gabrielle Gordon, and my co-host, Alexis Gamliel, is in the show notes. Thank you.